Mama ever say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
Told that today is for funds payment. Our honorary Chikata. So those of us who went to Korongo Duma Secondary School, some of us think that we went to the best secondary schools, but well, Your Excellency the Vice President, my lords, members of the diplomatic corps, distinguished members of the bench and bar, respected members of the academic community, eminent guests, traditional leaders. We've been told that this is, but those of us who like sports, those who, particularly football, to attest to the fact that when matches are live and you are sitting in the comfort of your home, you have the fortune of technology. Sometimes scenes can be played back even while the match is still going on. Unlike when you are in the stadium, sometimes even turning your head to talk to somebody, you may miss a scene. You may miss a goal, and you have to ask, what happened? So one wonders why people still go to stadiums. You see stadiums very full every time. Because of the statement, I was there. Everybody wants to tell people that when it happened, I was there. I saw it live. I wasn't hiding in the comfort of my room. This is why some of us feel very privileged to have been invited to even take part in this ceremony. It is with profound honor and a deep sense of institutional pride that I joined the UPSC Law School in celebrating an exceptional jurist, scholar, advocate, and public intellectual, Mr. Tsatsu Chikata, on the occasion of the conferment of this well-deserved Lifetime Achievement Award in law. The law, as we know, is not merely a profession, it is a calling. It demands intellectual rigor, moral courage, discipline of mind, and above all, fidelity to justice. Across decades of private practice, scholarship, and public service, Mr. Chikata has demonstrated an uncommon commitment to these ideals, coupled with a stubborn persistence at maintaining the ideals of excellence as a professional. His career has been marked not only by professional excellence, but also by an enduring dedication to the development of Ghana's constitutional order and the strengthening of the rule of law. Over the years, Mr. Chikata has distinguished himself as a lawyer of formidable skill and rare depth. His mastery of legal principles, his meticulous preparations, and his capacity to marshal complex arguments with clarity and precision have earned him the respect of the bench and the admiration of colleagues across generations. His submissions have frequently illuminated the deeper purposes of the law, reminding us that legal reasoning is at its finest when guided by principle and anchored in justice. In this sense, I dare say that he belongs to the rare breed of lawyers in our lifetime who see the law as more than just being a set of mechanical rules to be manipulated by lawyers to selfish ends. It is also pertinent to acknowledge the personal qualities that have defined Mr. Chikata's professional journey. Those of us who have encountered him in the practice of law recognize not only his intellectual capacity, but also his resilience, independence of thoughts, and steadfast commitment to principle. These attributes have enabled him to navigate complex and often demanding legal terrains with dignity and composure. The conferment of this Lifetime Achievement Award is not merely recognition of past accomplishments. It's also an affirmation of his enduring influence on the current generation of lawyers. Mr. Chikata's legacy continues to shape contemporary legal discourse and inspire younger members of the profession to approach the law with seriousness of purpose and clarity of thoughts. His example demonstrates that excellence in law is achieved not through momentary brilliance alone, but through sustained dedication over time. The judiciary, which I head, as the guardian of the Constitution and the protector of the rule of law, benefits greatly from the contributions of advocates who approach their work with integrity and intellectual honesty. Mr. Chikata's career stands as a testament to the constructive role that lawyers play in strengthening legal institutions and advancing constitutional governance. As we celebrate this distinguished honor, we are reminded that the law is a living instrument, constantly shaped by the contributions of those who interpret, apply, and critique it. The vitality of Ghana's legal system depends upon individuals who are prepared to engage thoughtfully with the legal doctrines and courageously the questions of public importance. Mr. Chikata's work exemplifies this tradition of principled engagement. To the students of the UPSC Law School and to young lawyers across the country, the career of Mr. Chikata offers important lessons. It teaches us that professional success is best measured not solely by personal achievement, but by the extent to which one's work contributes to the advancement of justice and the strengthening of institutions. It reminds us that the law is most effective when guided by ethical conviction and intellectual discipline. On behalf of the judiciary, I commend the UPSC Law School for recognizing the significance of honoring individuals whose work has enriched Ghana's legal tradition. Such recognition strengthens the values that sustain our profession and reinforces the standards to which we must continually aspire. Mr. Tsatsu Chikata, your contributions to the law have left an indelible mark on Ghana's landscape. Your work has helped shape the contours of constitutional debates, enriched legal scholarship, and strengthened the practice of advocacy. The respect you command across the legal community is a reflection of a lifetime devoted to the pursuit of legal excellence. It is therefore with great pleasure and deep respect that I joined the UPSC Law School and all of you here in congratulating you on this distinguished recognition. May this honor serve not only as an acknowledgement of your achievements, but also as inspiration to future generations of lawyers committed to the ideals of justice, integrity, and service. And now, ladies and gentlemen, please join me in celebrating a distinguished son of Ghana, an eminent lawyer and a valued contributor to our constitutional tradition, Mr. Tsatsu Chikata. Thank you for your attention.
Vice President, Chief Justice, Chairman of the Council of State, Vice Chancellor of the University, Dean of the Faculty of the School of Law, distinguished ladies and gentlemen, I am rather overwhelmed by this great cloud of witnesses, particularly the presence of the Vice President of the Republic on this occasion. Kofi Abochi didn't forewarn me that the Vice President was actually going to be in attendance. Thank you, Vice President. For fitting this into your packed program and for your kind words. Your own distinguished academic career, as well as your sterling leadership of the University of Cape Coast are well known. You are forever a trailblazer. And now, as the first female to hold the office of Vice President, you are showing your exceptional leadership qualities, as well as your lifelong commitment to service of this nation. I believe the nation is grateful, and I am grateful for your presence here today. May I at this point also acknowledge 3 women, 2 who are participating in this event virtually. My mother, Mrs. Annie Chikata. My aunt, Mrs. Georgina Apalu. And the third, my wife Esther, who is here in person. I owe special debts to these women, as will be evident shortly. I'm touched too that the Chief Justice is here. CJ has risen through the ranks to this highest level of office in the judiciary, humbly and patiently, maintaining a calm dignity throughout. Thank you, CJ, for your service to the nation. And thank you for your kind words today. The conferment of this Lifetime Achievement Award on me by the University of Professional Studies, Accra, is humbling. I'm grateful to this university, to you, the Vice Chancellor and Council, and to the School of Law, and particularly Dean Kofi Abochi, for doing me this honor. I want to thank especially Mrs. Betty Moldy-Drisu for her lecture today honoring me. There are important observations she has made about the affairs of our nation over the decades that should matter to us all. Betty has distinguished herself in her own career, including at the Commonwealth Secretariat, then becoming Attorney General, Minister of Education, and now on the Council of State. she carries all her laurels lightly and gives some credit to those of us who were her teachers in the past. She even relishes stories from the old days. Thank you, Betty. The subjects I taught from the early 70s at the then Faculty of Law, University of Ghana, Legon, were Ghana Legal System, an introductory course for first-year students, and Jurisprudence, a course for third-year students, which became my signature course, as it were. Jurisprudence delved into legal theory. What is law? And it ranged over various answers to that question that theorists had put forward over the years. A book by Professor H.L.A. Hart, The Concept of Law, had been a basic textbook from my student days. There was a question posed in the analysis of Professor Hart, which has stayed with me. How do we distinguish a legal system from a gang of robbers? Is law any more than a gunman situation writ large? What is it that makes laws obligatory? We lawyers certainly do not see ourselves as robbers or gunmen. We are learned friends with Esquire added to our names. Judges are lordships and ladyships. And I'm really deeply moved to see many of your lordships and your ladyships here. Again, I honestly did not expect you, but thank you for being here for this occasion. I would like us in all seriousness to consider whether we contribute to the well-being of society in a way that should make clear to the world the difference between a legal order and robbers and gunmen. When I entered the Faculty of Law, Legon, in October 1966, I began an immersion into what constitutes the corpus of the law of Ghana. Those 3 years of intensive study were not just about sitting in classrooms or in the law library. They also involved personal interactions with the lecturers and also with colleague students. Let me take this opportunity to acknowledge the impact on me from those years of Professor G.K.A. Ofoswama. He taught me contract law in my first year, but his influence on my life and understanding of law went beyond the law of contract, as he opened up his wealth of legal knowledge, his home, including library, and his very humanity to me. He literally held me by the hand after I finished Legon and took me to Oxford University to begin my postgraduate studies in October '69. Thank you, K. Dr. Thomas Mensah, who taught me Ghana legal system in my first year and became acting dean of the faculty before he left to work with the International Maritime Organization in London, was also one of my teachers whose impact has been lifelong. Apart from the time in Legon, after he moved to London, I enjoyed my trips from Oxford to his home in Golders Green, where I basked in the family atmosphere that his wife, Akosia, particularly always ensured. Even as I sat at the feet of Dr. Mensah, I honored their memory on this occasion. I cannot fail to mention the role of Professor Alex Kwapong, Vice-Chancellor of the University of Ghana, Legon, in my legal education. In my third year at Legon, the dean of the faculty was Professor A.W.B. Simpson, who had come from Oxford University as part of a cooperation program that Professor Kwapong had established with the Faculty of Law in Oxford University. It was under that program that we had a memorable visit from the legendary Professor Cross, a blind professor whose authoritative work on the law of evidence, among others, remains to this day a standard reference. Under the program, students were to go from the law faculty, Legon, to do postgraduate studies in Oxford. I was the first beneficiary under that arrangement. And I went to Wadham College, where Peter Carter, with whom Professor Kwapong had signed the MOU, was my tutor, as was the distinguished international lawyer Ian Brownlee, who later also came to the Legon Law Faculty for a year. What better career and life-shaping, precisely orchestrated, could a 19-year-old Strong Bay boy ask for than that? Professor Kwapong continued to keep a close watch on how I was doing, both as a student at Wardham and when I became a junior research fellow at Corpus Christi, till I returned to the Legon Law Faculty, initially for a term in October 73 and finally in October 74. Thereafter, till his passing, I had to make sure that he was satisfied that I was living up to all the investments he got the University of Ghana to make in my education. There were other teachers of mine at the law faculty, to all of whom I'm indebted. S.O. Jando taught constitutional law in first year, while in second year, J.K. Ajiman taught the law of torts and Kofi Deanan commercial law. Dr. Obed Asamoah taught me international law in my third year. Even as I acknowledge the influence of my lecturers, there was one colleague student with whom I worked together, not just as a fellow law student, but also as a brother in the University Christian Fellowship, E.V.O. Dankwa. He it was who stood by me as a lawyer when I was on trial from early 2001 until I was finally acquitted in 2016. He was ably supported as junior counsel during most of the High Court trial by a former student, Roland Agbanuto, of blessed memory, who had a distinguished career as a lawyer in the military and in private practice. In an interview for a UAC scholarship on 22nd December 1959, I was asked what I wanted to be in future. I boldly announced, without hesitation, that I was going to be a lawyer and subsequently a judge. Of course, with parents who ignited in us their children from a young age the zeal for reading books in the quest for knowledge, and who spared no effort and resource towards our education, ambitions like that should not surprise. My siblings and I were blessed with such parents. Our mother, who had been a pupil teacher, was also a home teacher. In my specific case, my mother also bore the brunt of my being asthmatic from about age 4. She was often with me in hospital. Forever etched in my memory is my mother lying on the floor at night beside my hospital bed during some of those episodes. I can't, however, leave out the story of 17th July 1959, when I was scheduled to take the common entrance examination. A dawn attack of asthma threatened to disrupt the plan. My mother was in Kolebu Hospital about to deliver a newborn baby. It was my father who took me to his friend Dr. H.S. Bannerman's clinic at Mamprobi. After I obtained relief from treatment there, I insisted that I was well enough to go for the common entrance examination. Incidentally, the baby girl born on the 17th July 1949 also became a lawyer, my sister though. By God's grace, asthma did not derail my educational progress. Not even when during the second term of my first year in Fansivim, Headmaster Bartels invited my father to the school for a discussion about my health and proposed that I go home for the rest of the term and start Form 1 again from the next academic year, which was that year's 1960, to start from October. Thank God I defied the adults. Parental steering towards law as a career was sealed by the close relationship between my parents and my uncle, Justice Apalu, my mother's big brother, whom I have to hold responsible for the answer I gave at the UAC interview, especially the part about becoming a judge, which I'm not able to fulfill. From when he returned to Ghana in the early 1950s, after qualifying as a barrister in England and throughout his career, ending up as a Chief Justice in Kenya after having been Chief Justice in Ghana, he was very much the role model, not only for me but for all my other siblings. He was a model of legal erudition and wisdom, as well as judicial comportment, and had our attention from our childhood. His wife, Auntie Georgie, was very much a part of our attachment to our uncle, and she has remained a constant source of encouragement to this day. When I returned from Oxford to Legon to teach, I was soon thrust into part-time practice of law because of the state the country was in and in my quest to contribute to a better Ghana. As junior counsel to Joe Rindolph, the preeminent legal practitioner of his generation, I was involved in cases such as a habeas corpus application for the release of some 259 prisoners in various prisons around the country, Republic versus Director of Prisons, ex parte Ango Dagomba was the name of that case, and an application seeking the release of Mr. William Uferiata Pawili from custody, both cases during the Champong regime. Incidentally, I had become close to Pawili from the Legon student days, when he came from time to time to speak to us at the University Christian Fellowship. A few times after his talk, Pawili himself would stroll with me from the meeting place above the bookshop to my room in Legon Hall. My roommate then was his nephew, Duke Dankwa. I remember Pawili once encouraging us to go and watch the film 10 Commandments, which was then showing at the Orion Cinema, and giving us money for the purpose. And we did go to watch the film, we didn't just spend it. I was also junior counsel to Joe Rindolph, together with Professor Akila Akpasoya and Dr. Kwesi Boche, in representing Captain Kojo Chikata before a military tribunal at Burma Hall in 1975. Joe Rindolph was undoubtedly the lawyer from whom I learned the most in legal practice. His advocacy was formidable and eloquent, a joy to behold. Ironically, we were on opposite sides in the well-known case of Amoakutufo and Attorney General, which was about whether Chief Justice Apalu had to undergo vetting before Parliament to maintain his position upon the coming into force of the 1979 Constitution. Joe was then serving as Attorney General. The trial of Flight Lieutenant Rawlings after the May 15, 1979 uprising obviously thrust me into the national spotlight, irreversibly, I may say. It was a time of great agitation in the nation. A line of Rawlings' statement to his investigators, "Leave my men alone," which was quoted in the opening prosecution statement by the Director of Public Prosecutions, G.E.K. Akins, captured the imagination of the nation, appearing on the front page of the Daily Graphic. It showed a readiness to take responsibility as a leader that endeared him to many. I was led in that defense by the then president of the Ghana Bar Association, Mr. Bosman, as Betty mentioned. A number of other reputable lawyers, such as Emil Short, were also involved as counsel for the co-accused. And as we know, that trial ended with Rawlings being sprung out on the morning of 4th June 1979. A few days before 4th June, on Saturday, 1st June, I was going to the Air Force Mess in Burma Camp for the wedding reception of my classmate, Kwamna Anaman. Driving from Legon, I had a problem with my car just about when I reached the roundabout at 37 Hospital. I decided to park the car at a convenient location and get a taxi to the Air Force Mess. On arrival, I took out a note to pay the taxi driver, who then was having difficulty finding change. Across walks a young man, obviously a soldier, but not in uniform, who must have recognized me from my being at Burma Hall that week for the Rawlings trial. He asks the driver how much the fare is, pays the driver, then as the taxi leaves, he turns to me and confidently says, "Don't worry, your man will be out soon." The calm assurance of that young soldier in essentially telling me about an upcoming coup d'etat is quite unforgettable. Ghana has come a long way since those heady days. The Fourth Republic has provided the longest period of stable constitutional democratic order for the country. This is something and guard jealously, not take for granted. The legal profession, and in particular the judiciary, have important roles to play in sustaining this order. So we must examine ourselves honestly and speak frankly if we are to deserve the confidence of the society. I found it sad during the election petition following the December 2020 presidential election that the expression unanimous FC became the name of our Supreme Court. The challenge to the declaration of results formally announced on 8 June 2020 by the chairperson of the Electoral Commission required a fair and just adjudication. It was not in dispute that the figures of the outcome of the election that were announced by the chairperson of the Electoral Commission were corrected in a press release by the public relations officer of the Electoral Commission. Subsequently, the figures that were presented in response to the petition by the Electoral Commission, returning officer, the chairperson of the Electoral Commission, even though she had deposed to an affidavit verifying the answer of the Electoral Commission and was supposed to testify, did not testify to present the authoritative final figures, much less explain the ever-changing figures from the Commission. To this day, therefore, the country has no definitive accounting for the 2020 presidential election. In the face of evidence of her failure even to be in attendance at the process in the collation center at the EC head office, the declaration of results that she made was even more problematic. Unanimous FC was the verdict of the people on the proceedings in the Supreme Court, which shielded the returning officer from accounting to the people of Ghana. The negative reaction of ordinary people to the appearance of judges to participate in the swearing-in of the new president on 7 January 2025 was an unfortunate reflection of the people's attitude to the unanimous FC. I may also say that from the point of view of President Mahama, whose election petition was dismissed by the unanimous FC, vindication came comprehensively in December 2024. What he could not have done with the hanged parliament after the 2020 election, he now has a chance to do decisively with a supermajority in parliament. This vindication, however, comes with a heavy weight of responsibility and expectation, which I believe the president is conscious of. Let me recall, sadly again, that in December 2020, the people of the Santro, Kofi, Akpafu, Likpe, and Lolobi South traditional areas, by an announcement on the evening of 6 December 2020, were prevented from voting in the Hohwe constituency they had previously voted in under a valid constitutional instrument. Yet a winner was declared of the election in that constituency, and he served in parliament in a period when the citizens of Ghana in the South traditional areas had no representation in parliament. That was an undermining of the very fabric of the Republic of Ghana, in addition to being a violation of the fundamental human right to vote of those disenfranchised citizens. Professor Margaret Kweku and other petitioners first sought from the High Court in Ho remedies for the human rights violation. The High Court in Ho granted an interim order of interlocutory injunction. The then Attorney General ran to the Supreme Court and had the court pronounce that since one of the remedies being sought was the invalidation of the results of a parliamentary election, the procedure of an election petition in the High Court was the only procedure to be used to bring the matter to court. The Supreme Court cited some of its earlier decisions in cases involving J.H. Mensah and Baba Jamal, among others. The interim order of interlocutory injunction lapsed. The petitioners then filed an election petition and went through a process of trial, where again the Electoral Commission chose not to testify to explain their conduct. In July 2024, the High Court decided that it did not have jurisdiction over the matter. Following an appeal, the Court of Appeal recently quashed the decision of the High Court, but now stated a case for the determination of the Supreme Court. Judicial remedy for the disenfranchisement in December 2020 of Ghanaians in the South traditional areas is still pending. It cannot be said that the subsequent creation of a Guan district and a Guan constituency are sufficient to remedy the injustice to the people of Sao. For one thing, the mere denomination of a district and a constituency does not provide the development resources that are the legitimate aspiration of the people. For the period they lacked representation in Parliament and a share of the resources that could have been available through a member of Parliament, I dare say they are owed reparation. The historic injustice of the declaration by the EC of the election of a member of Parliament for a constituency to which they belong but were denied a vote in awaits judicial resolution. Please remember that the EC itself has admitted that it would have been illegal to have asked the voters in those areas to vote in the Boem constituency in December 2020. Yet, that is what the constitutional instrument which the EC has claimed in its defense to the election petition to be the applicable instrument. That is what that instrument would have required. There is an unsettling judicial contradiction, which I must also point out. While the Supreme Court, in respect of Sao, insisted that an election petition in the High Court was the only way to invalidate an election petition, when it came to an action initiated in the Supreme Court to invalidate the result of a parliamentary election in Asin North, the Supreme Court dismissed an objection to its jurisdiction to invalidate the parliamentary election that was based on its own previous decisions, went ahead to grant initially an interlocutory injunction preventing the elected Member of Parliament, Honorable Jachi Kwesen, from being in Parliament. Remember, this was the time the e-levy was being pushed through. And eventually delivered a final decision invalidating the Asin North parliamentary election. The resulting by-election, however, saw Honorable Jachi Kwesen win again with an even bigger margin. Despite all the machinery of government being massed up against him, new roads suddenly being constructed in the area, the president, vice president, and the whole machinery of the party in government moving in to campaign against him, he maintained this remarkable victory streak in December 2024. During the period when the interlocutory injunction prevented him from being in Parliament, the people of Asin North were deprived of representation in Parliament at a time when important national issues such as the e-levy were under consideration. Honorable Jachi Kwesen, who also faced an obviously politically motivated criminal trial from 2022, was fortunately acquitted in April 2025 on all charges upon a submission of no case. And he now serves our nation not only as MP for Asin North, but also as the Deputy Minister for Foreign Affairs. I must also speak about my own experience of being tried and imprisoned, as these two provide lessons about the misuse of both executive and judicial powers. Upon an application by my lawyer, EVO, the Supreme Court, by a 5-4 majority, declared unconstitutional both the so-called fast-track High Court, before which I was arraigned, and my having been summoned to the court in the name of the president. I think I may be one of the only people, I'm sure I'm the only person since Republican Ghana who has been summoned to a court in the name of the president. And that was despite the fact that the Constitution requires the independence of the judiciary. Now, after that 5-4 decision, as Betty pointed out, President Kufuor immediately took steps to appoint 2 new judges to the Supreme Court for the express purpose of enabling Chief Justice Redu, who was one of the minority in the 5-4 decision, to empanel those 2 new members of the Supreme Court as part of the review panel. The then Attorney General, later President Nana Akufo-Addo, held a press conference after the Supreme Court decision, condemning the judges in the majority for what he called a perverse decision. According to plan, the review ended up overturning the earlier decision by a 6-5 majority. Police were sent on the Sunday after the first decision of the Supreme Court to the church where I worship to arrest me. I had always made myself available to the police. The only reason for that particular event immediately following the Supreme Court decision in my favor was to show that even that court decision did not matter to the powers that be. Later that same week, new charges were brought in a normal high court against me. These were again dismissed on the basis that they were unconstitutional, being in breach of the clear constitutional provision against criminal legislation being used retroactively. Once the president got the review panel